is Claudia Barber, and I am a practicing attorney, former judge with the District of Columbia Office of Administrative Hearings. I served as a judge for more than 10 years, from 2005 until 2016. And I also have been really in the legal career as a licensed attorney for more than 35 years. I served for the National Association of Women Judges. I am a lifetime member of that organization, and I have served in many capacities, including District 4 Director of the DC, Maryland, and Virginia areas. And I have also served on the board of the District 4 prior to becoming the District 4 Director. So I have enjoyed the legal career for more than 30 years, and I continue to work in that capacity. The book that you're referring to is How to Survive Protracted Civil Litigation When the Judicial System Stopped Being Fair and Impartial. How to Survive Protracted Civil Litigation When the Judicial System Stopped Being Fair and Impartial. The book really is something that came after many, many experiences that I have had as a lawyer, as a litigant, and as a judge. And the perspective that is really put together in the book also embodies the judicial perspective. And it gives you tidbits of what the public doesn't know. They might guess, but they don't really know. In my being in the judicial capacity, I just share exactly what I know. I share exactly what happens when there's weighing in on cases. I share the good and the bad. I identify patterns of bad judges. I identify patterns of good judges. I share that judges have access to social media, and they have access to news just like anyone else. So when litigants come before them, they too are in some way impacted by whatever news media sources are out there. And the question is whether or not judges are being fair and impartial, or are they in some way persuaded by what they see in the news media. Because the mass media has a major impact on how we think, and in many ways, mass media defines people. And that's, to me, is a bad way to go, or that is a disappointment when the judiciary takes what the media says at face value and define people by what they see in the press. So that's where I'm coming from, this multitude or multifaceted and diverse background of experiences. I put it all together and I share that information in this particular book. I also reference that the legal system wasn't designed for the economically disadvantaged. In fact, I am currently working on a case right now in which a client has to appeal a divorce proceeding and a judgment of absolute divorce. And it's staggering at the appeal costs that are involved when someone has to file an appeal and prepare an appellate brief. So these are, again, financial barriers to justice. Either you can afford the appellate costs or you can't. And if you can't, you're stuck with the decision of the lower court. So these financial barriers are real, and they are identified and addressed in the book. Well, I think it stopped being fair and impartial when they overlook the financial barriers that litigants face on a daily basis. They missed it entirely because there are way too many litigants, and many times the majority of people who use the legal system are poor people. You know, they're confronted with if it's not a criminal matter because they live in poverty and they're targeted by law enforcement, or it's just the fact that there's possibly discrimination in the employment industry that blocks them from getting ahead. So they're left with a low-paying job or a job that still has limited resources for them. They're using their disposable wages to make ends meet in their family. So they don't have $10,000, $20,000, $30,000 in cash to put on a case to seek justice through the legal system. They don't have it. And to the extent that they don't have it, what kind of justice are you offering them? So these I consider shortcomings. These are considered shortcomings of the legal system. You know, when we look into the money and resources that, for example, went into the Donald Trump, USA versus Donald Trump trials all over the country. And let's say we stop at Atlanta, Georgia. All the monies that was invested in digging through the prosecutor Fannie Willis's background and pulling up records and talking about tracking devices and talking about money spent and going through bank accounts, that requires a multitude of hours of resources to put such a case together. And for the average person, I would estimate that might be in the millions of dollars to go after, to put litigation together, to attend hearings, to have the documents together, to have the exhibits together. And that's another thing. When you are dealing with the judicial system, it's all about timing. If you can't wait for a transcript to come from California and you're on the East Coast, if you're trying to order the transcript and save costs, you might have to wait 30 days. Whereas if you order the transcript on an expedited basis, you can probably get it there in time for the deadline for the proceedings. So you have those nuances and situations that exist every day in litigation. Timeliness of documents, timeliness of ordering transcripts, timeliness of receiving evidence. If you don't have the evidence in time for the trial, then that could just basically ruin your case. It could cause your case to be dismissed. It could cause your case to be delayed or not heard at all. And if your case is dismissed, that impacts your litigation, your access to justice. And this is the key that must be addressed. Access to justice. Is it real, or is it perceived, or is it not real? If you're going to give people access to justice, then you have to take into account, again, the financial limitations that people have when they are involved in litigation. Sometimes they don't get asked for it. They're just a lawsuit comes out of anywhere. And when they are not involved with the city, or they have to pursue justice to get their job back. They have to pursue justice to clear their name. They have to pursue justice to get their records or their credit straight. So again, these limitations are real, and they are shortcomings in the system. What can be done is we can take a realistic approach to where we are and where we need to be. For example, what I do discuss in my book is some of the initiatives that the Maryland Judiciary, they did create a panel or a committee on diversity. And one of these initiatives is to explore the disparities, for example, in sentencing. That's a start, okay? But it doesn't go far enough, because what about the people who have already been impacted by disparate sentences in the past, and their case is over, and their appeal period has expired, and they could not afford an appeal, or they used a public defender, and even though they used a public defender, they got their 3-judge panel to hear the case, but the case still didn't go the other way. There are alternatives such as the Innocence Project, Equal Justice Initiative, and similar forums. That's great. And why do you have those resources or those organizations out there? They must exist, because every time we hear about the Equal Justice Initiative, they are getting someone out of jail that was wrongly convicted of a crime. That has to happen, because you look at the story of Anthony Ray Hinton, who was put in jail for decades, and he wrote a book, The Sun Will Shine Again, but he was put incarcerated and charged with a murder he did not commit. There's got to be a strengthening of laws to go after people who doctor evidence, who fake evidence, and cause people to lose their livelihoods and their careers through false incarcerations. There has got to be better forces in line. For example, the state legislature was considering legislation where personnel lose their pension if they are incarcerated for misconduct and they cause someone to be wrongly convicted. That's a start, but that's only just surfacing within the last 5 or 10 years. And there should have been, long ago, these types of major changes and investments into making the system better and making it more accessible to the public. There are options that I provide in my book on how people do get funding, crowdfunding, like the Kyle Rittenhouse case and the George Zimmerman case. But there are other resources from pro bono operations, but they can't handle every single case because you're talking about an organization that can handle less than 100 cases, and you have thousands of litigants who need legal representation and quality legal services and need to pay for expert witnesses. That's another thing. In these employment discrimination cases that you try in federal court, there's something called Dobert motions. and challenges to your expert witness, and whether or not the witness is peer reviewed, and whether or not the expert witness it suffices. People who are poor can't afford an expert witness that is peer reviewed and is at the top of their chart. So this is unrealistic, and it's a shortcoming again of the system because it's not trying to do its best. To me, that's just really trying to do your worst. So those are the types of issues that are presented in this book, How to Survive Protracted Litigation. And, I want and hope that people will buy it. It's been trending well on Amazon in the category of judicial system and litigation procedures. But it's also available in Barnes and Noble, also available in Books A Million type of bookstores. So it's really an important read for many who are faced with legal challenges.